Thank you, Brenda, and thank you all for having me here today. And as Brenda said, we've had an institutional interest in this issue. As you might imagine, the public defender finds ourselves often fairly alone in Annapolis trying to articulate the viewpoint of criminal defendants and persons in the criminal justice system. There's a lot of victims advocates, and it's very politically expedient to be tough on crime, quote unquote. And so that's a trend we've seen for decades now. And particularly in tough economic times when there's not much money to do much else, it's easy to create more draconian criminal laws, create greater penalties, longer sentences, and things like the sex offender registry, I think, is very much a part of that line of thinking. Of course, there's legitimacy in a concern for public safety, but the public defender really wants to ensure that our laws and everything related to our criminal justice system is proportional, it's rational, it's constitutional, and it's geared towards enhancing public safety, not making it impossible for people to have a second chance. And so I think in those ways, and of course in specific ways, we have a lot in common with FAIR and are happy to be here partnering with you all. So Brenda asked me to speak a little bit about the public defender, and then I think hopefully you'll find it helpful, talk a little bit about the process of testifying in Annapolis. As you might imagine, without hearing from you all directly, there's a lot of supposition, there's a lot of stereotypes, there's a lot of fear that is not being counterbalanced by your faces, your facts, your lives. And all of us have something to contribute to the democratic process, to the process of these persons deciding, is this the way we want to go? Is this not the way we want to go? Do we want to go harsher? Do we want to be more balanced? And you all play, I think, potentially play a very important role in creating that counterbalance so that legislators and others can say, these are the consequences of our decisions. These are the people that we're talking about. These are the effects that happen when we create these different policies. So I really want to encourage you and make you feel like you have a contribution to make. And of course, that'd be very helpful to us because, like I said, we're often the lone voice in Annapolis representing these perspectives and issues. So I handed out just a one-pager. You don't obviously have to read it all in detail, but it does describe some of our agenda in Annapolis for this upcoming year. And I should say, in terms of our vision, I think I should add something. Coming over here, driving over here today made me realize one thing that's particularly, I think, part of the reality of the registry that isn't really expressed here, and that is the idea of redemption, the idea that after paying a certain price, one is free. The actual definition of redemption is freedom after paying a price. And the idea of the registry is practically, for many people, you've got to pay that price no matter what for the rest of your lives, and you've got to deal with the consequences of something that happened, and you're never set free from that. And that, I think, is part of the underlying injustice that we have to communicate to legislators, that we have to let them know that our criminal justice system has gotten out of bounds. It's gotten too much towards this, you'll just never end paying me back for what you did. And I think there's got to be some rationality to that. There's got to be some proportionality to that. And the way that I like to express it is this idea of redemption. There is a price to pay. There is time that you need to do. There is a sentence that you need to serve. Maybe there's probation that you need to live with. But the stuff that just goes on and on is too much. And we need help. down in Annapolis to communicate that to people and to really convince them that we need to create a more balanced approach to this issue. And so with that, I guess I'd like to just kind of get into some of the tips on testifying. And the elephant in the room in terms of testifying is always fear of public speaking. There's not any manner of mechanisms or tips or strategies that I can teach you that are going to really work if you are living with a certain fear of public speaking. And so it's always, I think, helpful to try to address that issue first, see what we can do with that, how we can help with that, and then get into some of the specifics of what are some helpful ways to communicate to legislators in Annapolis specifically. The PowerPoint that you have in front of you is pretty general. It applies to any type of communication in public, but it is written in light of my years of experience in Annapolis, and particularly working with persons who are not professional public relations persons, persons who have an important point of view to add, but they're not in the practice of, like me, basically testifying just about every day of the week, multiple times a day. And so obviously there's a certain amount of fear, a certain amount of anxiety that's natural when you just are asked to do something that you don't do that often. And public speaking, of course, is one of those things that generates a lot of concern. So what I like to tell people in terms of combating fear of public speaking is to have some confidence in three things. You'll see it at the bottom of that first page. Your purpose, your competence, and your preparation. And what I mean by purpose is there's a reason why you're there. And that reason is often what's going to carry and help you have a sense of confidence about what you're doing. If you set yourself up with really high expectations in terms of, I'm going to be the person that goes in there and convinces the entire committee to vote for this bill, you're putting a lot of pressure on yourself. I'm the person that's going to say that one thing that gets the one vote that helps pass this bill or helps kill this bill. Leave that to those of us who have to do it every day. What you need to do is express yourself and your own experiences and your point of view. And these are interrelated, but having confidence in your purpose is also about having confidence in your competence. And by that I mean that you are the expert on you. You are the expert on your personal experience, on the consequences of the law, on how the policies and practices have affected your life, how it makes it difficult. And so you have to have ownership over what you know about how you've experienced life because of these things. And that's what you need to really focus on when you're being asked to present yourself and to present arguments against a bill. If you're not an attorney, you don't need to worry about the legalities of it. If you're not a police officer, you shouldn't worry about how things should work on their end. Whatever your point of view, whatever your place is in the spectrum of the policy that's being discussed, that's your area of expertise. And have confidence in being able to say, this is my experience, and this is what I'd like to share with you about that. This is why I want you to do this with this bill. And that's the last point about priorities. You have to communicate to legislators that we can all have different opinions, and my particular opinion about this is that I'd like to prioritize, for example, a balanced approach. Or I'd like to prioritize distinguishing between more severe forms of criminal conduct and those that are less severe. And is it fair that those on one end of the spectrum are receiving the same consequences, the same sentences, the same treatment that those on the other end of the spectrum? So there's any number of things that we could talk about. But just in terms of general ideas, think about what you want out of the situation and be confident in expressing that to others who might disagree. It doesn't matter. We all disagree with each other about any number of things. That is the democratic process. But the idea is that you're there thinking about your position, your point of view, and expressing it. In terms of the preparation piece, again, this is just very general. It's a matter of organizing and practicing your thoughts and your delivery. And what I mean by organizing your thoughts is you just need to sort of sit with the issue, sit with what it is that you want to express, and give yourself just enough time to really think, here's what I want to say first, here's what I want to say after that, here's how I'd like to conclude my presentation. It doesn't have to be something that's super complicated. It's not anything that has to be long. But if you're taking the time to testify, if you're taking the time to help FAIR or any other organization express a certain viewpoint on a policy or on a bill, take the time to prepare yourself and just think, what are the three things? What are the three things that I want to take the time to really emphasize in this situation? And oftentimes, as I've been suggesting, that's almost an internal process. You're really focusing on your own perspectives. There are professionals and persons, for example, like Brenda, that can look at national trends, that can look at statistics, that can look at numbers and data and sort of bring perhaps that viewpoint. If that's something that you do, that's great. You could add those things to the mix. But what I'm suggesting in general, and I'm presuming, I'll be honest with you, I'm presuming most of you have not had experience testifying in Annapolis. Actually, let me just, who has had experience testifying in public in Annapolis? So we've got 3 people. Okay, so luckily my presumption wasn't way off. So most people are pretty new to the idea of doing this. And thank each of the persons that have testified in Annapolis. And I'm sure they'd hope to see more of you doing the same. Organizing your thinking and practicing your delivery. Sometimes there's not that much time, particularly for those of us who are running back and forth. But in most of your cases, you'll have a bit of time to do an outline. Some people prefer to have their testimony written out word for word. That sort of delivery of testimony where you're actually reading off of a piece of paper is particularly discouraged in Annapolis. And so if you feel like you're a person that couldn't speak off of an outline or off of a set of notes, I would say you should probably think twice about going down to Annapolis, because they will often tell people who are reading their testimony to stop reading and to simply, sometimes they'll say things like speak from the heart, or just tell us what you want to say, don't read what you want to say. And so it is what it is, but just to give you a heads up, if you are planning to go down this year, it is much better to use the sort of notes that you see in my PowerPoint presentation, just those keywords that help remind you about the points that you want to cover, and then deliver it, as you would in a conversation, etc. Practicing delivery is just, we've all gotten these tips from high school, like go to the bathroom, look at yourself in the mirror, and practice for 3 minutes. Just do it in the shower that same morning, etc. However you want to practice, it's obviously helpful to have some feedback. In a group like this, where I can sense there's a lot of mutual support, you can probably reach out to some other people and say, can I take 5 minutes? Can you listen to my testimony? You can do it in person. You can do it over the phone, however you want to organize it. But the idea is to at least practice a couple times, just going through the motions. So shifting then, so I hope what I've helped cover is a little bit of the why and sort of how to deal with the fear aspects. The next real, and this is relatively short, but the next part of what I'd like to discuss is the content piece. My advice on how things are best communicated in Annapolis based on my experience. There's a lot of different approaches. Some people can be very personable in their approach. Some people can be maybe more statistical and data-based. Others can be kind of bombastic and really sort of, how would I say this, very dramatic in how they present themselves and the arguments that they're making. The manner of style is up to you, and it's based on who you are. I like to see people who are dramatic, but I also love to see people who are humble and relatively quiet in their delivery. All of those things are legitimate. Those aren't things I would say you need to worry about. But the following suggestions are really what I think makes the difference between legislators hearing what you're saying and taking what you're saying into account versus those times when they might just sort of more generally be reacting to you and not really hearing you as much. And so those particular suggestions are: make it clear, make it concise, and make it convincing. So clarity is really just going through your thoughts one at a time. That's the most important thing. And it's natural for us in just day-to-day conversation. We might be talking about something, and then we kind of remember something else, and we'll kind of go there, and then we'll go back to what we were talking about originally. All of that's fine in sort of day-to-day communication, but when you have a limited amount of time, and most times your testimony in Annapolis is going to be a maximum of 3 minutes. Most chairmen will not allow you to testify beyond that amount of time. If you get more time than 3 minutes, then you're relatively lucky. It's more of an accident than a plan. And so again, in terms of practicing your testimony, give yourself that 3-minute window to practice in. But because of that time limitation, and there are a lot of complicating things that you might have to address. There's a lot of history or personal things that you might want to get into. So 3 minutes might feel a little bit tight. And again, being clear, sort of thinking about how you want to address things 1, 2, and 3, and making sure that you're going and completing your thought on one thing before going to the next really helps legislators hear what you're saying and sort of process it. Put yourself for a moment in the shoes of legislators. They're down in Annapolis for 90 days. Last year, which was a light year, there were 2,400 bills introduced. Each of those bills gets read on the floor. It then gets presented in committee. It gets voted on. It gets read a second and third time on the floor. It gets voted on in the House, let's say, and then it goes over to the Senate. The whole process repeats itself, comes back to the House for final approval, and then may or may not get signed by the governor. So legislators, and this is happening thousands of times over, and hearings are all scheduled for 1 o'clock, and so you will have a list of bills. Sometimes, for example, this last week, bill lists for hearings were typically 3 or 4 bills because we're just getting into the session. Later in the session, it's more like 13 or 14 bills, all of which start being heard at 1, and we will typically, towards the middle and end of session, get out of hearing rooms at 6, 7, sometimes 8 o'clock at night. So you're sitting down, and you've got testifier upon testifier upon testifier coming to talk to you about, let's say, 15 different issues for 7 hours. That's not easy to kind of keep your attention going, really focusing on what people are saying. And so it does kind of stink sometimes when you look across and you're speaking to the committee members, and some of them are sort of in their laptops or maybe taking notes or even taking a call on their cell phones. But you have to imagine they're there for 8 hours, and it's tough. It's just tough. So it is important. It is important for you to make the most of that little time that you have. And so again, the idea behind clarity and the idea behind being concise is that you're giving yourself the maximum opportunity to have something click with that legislator, who will then remember that when they then have to vote on the issue maybe a week later or so. So the concise, here I say up to 3 points. 3 subpoints, 1 page, or 3 minutes max. So again, I've already talked about the 3 minutes. If you can write your testimony on one side of a page, or if you can write an outline of your testimony on one side of a page, that's sort of the ideal. That's what you should be working with. If you're really feeling like you need to address more than that, you probably want to work with somebody to think about how to prioritize your points. There's also a matter of strategy, particularly for an advocacy group as FAIR. Because you're working with 3-minute increments, often what you'll want to do is have multiple people testifying to different aspects of the issue. And so that way, any particular person who's testifying won't feel like they have to cover so much ground. They'll be able to focus on, their particular aspect, have somebody else follow them up with the next piece of the puzzle, have a third person sort of finish it off with a third piece. And depending on what kind of ground you have to cover, you can have multiple people. But the concise thing is definitely one of the most important pieces of communicating your viewpoints in Annapolis. The last part is the convincing part. And again, here, I want to really encourage you to not think you have to be Martin Luther King or Gandhi or some orator of incredible renown, right? All of us have something to contribute, something that's valuable based on our own experiences. And so the specifics on the convincing tip that I'm offering is real life examples. And obviously this is something that all of us, depending on the issue, can provide. Carefully chosen and carefully expressed comparisons and analogies. I've seen this flop a number of times in Annapolis, particularly if somebody is thinking off of the top of their head and trying to maybe drive home a point and hoping to make a comparison with something else that helps illustrate what they're saying. You really want to be careful about that, but if you are careful about it and you carefully choose how to compare your situation to that of somebody else's, or if you can think of an analogy that helps people understand what you're talking about in terms of how registries operate in your life, for example, then go for it. That is very helpful for legislators to sort of think about these issues in terms that they can understand. So I encourage you to be creative, but at the same time to be careful about the use of comparisons or analogies. But it's an important tool to have and to use if you can. And then the last point is on data and statistics. It's a way to bolster your arguments. And so you've got to be, again, just careful in terms of what data and statistics you choose. You've got to make sure that they come from credible sources. And it's not that they necessarily have to be uncontroversial, but you just want to be able to refer to numbers and data and trends and things like that when you can. It's something that will often sort of catch legislators' ears and pique their interest. The other thing about the use of data and statistics in particular is if there are ways to express it. If you've got a number that expresses the presence of something in a community. Let's say, for example, the number of armed robberies in a particular neighborhood, right? You could say in so-and-so neighborhood in 2006, there was a 6% spike in armed robberies for a total of an absolute number of 632, right? So there's a lot of numbers there. That might be an impressive number. It might be meaningless to the person who's listening to it. But if there's a way to use what's called social math and transform those numbers into everyday experience. So for example, you could say, based on the population of town X, the number of armed robberies were so high that if they were to happen over an even amount of time, each member of that town would have been robbed once every 5 days or something like that, right? So you're beginning to use the numbers in ways that people begin to interpret in real life. It's not just a string of statistics or percentages. It's sort of creating a situation with the numbers that they can then relate to and say, well, every 5 days, that's a lot. You know, that means my neighbor's going to be robbed on one day, and 5 days later, I'm going to be robbed. And so obviously that's not going to happen that way, but that's what is meant by the use of social numbers, is to try to transform the numbers into a way that people can relate to it and sort of feel the impact of the numbers. I'd say the next best, and in certain circumstances, maybe even better ways, to just write a letter. Just write a letter to, often the chairman. And in today's technology, particularly through emails, you can write a letter to one person and CC. For example, you could write a letter to the chairman of the Judiciary Committee. There's 22 members on the Judiciary Committee. You write a letter, email it to him, and then you CC the other 21 members of the committee. You press a button, and you've hit them all at the same time. And they are all getting the information directly from you. And often what that does, and so I've actually seen it, I don't know if folks have ever looked through a bill file, but a bill file is basically all of the communications that occurred during the debate over a particular bill. And legislators will always put email communications that they receive from constituents or other persons. And so that becomes a permanent part of the record. And I'm saying this to encourage you because it does have influence. They speak to each other about emails that they get, as well as phone calls that they might get. But in terms of, your specific question, maybe not wanting to sort of publicly be out there and personally testifying, writing a letter, even just a casual email that's not more than 3 or 4 sentences saying, this is who I am, this is where I live, this is how I'd like you to vote, and just maybe 1 or 2 reasons why. It's a very simple, easy, and I think influential way to get your point of view to the committee members and to influence the decision-making process.
I know from my experience, one of the things, the first year especially, you were talking about, they're going to be distracted. They're going to be, all over the map. And it really can be very disconcerting you're up there, you've got your 3 minutes and you really want to get this thing out, and you see a couple of people get up and walk out of the room, or, somebody's reading something, or they're looking up to the sky, and you feel like that's so rude, and you want to lose concentration. But it is true. They are, they're multitasking is what's happening. That oftentimes somebody else just like you is busy calling them on the phone to find out about another vote they're going to give the next day, or so you just have to ignore that, and because often they have an aide that's back in an office somewhere that's listening much more intently than they are, and will make sure that they hear what they need to hear. That's not so much a question, but I know that that's
Right.
an issue
Right, absolutely.
for a lot of people.
And I mean, there are times when legislators will be rude. That's the fact of the matter. Sometimes they will respond very stridently towards something you say and may have questions for you that are very pointed. And there have been some breakdowns, I think, in just basic respect in Annapolis. And anybody who's been down there, I think, it's fair to say, would admit to that. But that's really the rare case. Other things that a lot of people interpret as being rude, for example, getting up and leaving during the middle of somebody's testimony, in some ways are rude. But for example, a legislator, just as a bill has been presented in that committee that you're speaking on, that legislator will have to go to another committee to introduce his or her bill to another committee. And just because of, as I've said, the fact that there's hundreds of bills flying around in the process, it will often be in the middle of a hearing they're listening to, that their aide will call them and say, your bill is going to be up over on the Senate side in 5 minutes. You need to go and introduce it. So sometimes they just have to go ahead, get up, leave the room, and then they'll come back at a later time. So that's an important thing to be aware of and to anticipate. But I will say there is almost always at least a couple of legislators that you can tell are paying attention. They're focusing on you. They're looking at what you're saying, and they're really processing what you're saying. I think one of the techniques is to really avoid paying attention to the distractions and really focus in on that one or two people that you see are looking up from their desks, are looking away from their laptops, or taking notes as you're speaking, and really focus in on them. And that helps encourage you, I think, and it also helps you keep focused on your message when you feel like there's at least a couple people who are really paying attention to you. And that really helps. You know, you can get pretty nervous and distraught and I think discouraged by focusing on people who aren't paying attention to you. So do the opposite. Focus on those one or two people that really are. And I know that obviously helps me quite a bit. I don't think I've been at a hearing where it's been a registrant, him or herself, actually testifying. It's always been family members. So I couldn't actually speak to that particular distinction, but I do want to encourage registrants themselves to show up. But in my position where I was working, we had to try to defend against what was often very anti-immigrant sentiment in Annapolis with regard to issues like driver's license. Just last year, the issue of in-state tuition. I was no longer professionally involved with the immigrant community at that point because I was here at the Public Defender, but I was following the debate very closely. As you know, immigrant issues can become very emotional. One of the things that was really surprising to me, I'll just be honest with you, is that the advocacy community on behalf of immigrants would bring very large numbers of immigrants down to Annapolis who would do nothing other than simply sit down in the hearing room. In some cases, they would bring so many that they would have folks lined up against the wall just standing there. And there were a couple reasons why they weren't testifying. In many cases, a lot of those immigrants didn't speak English. And the reality was, in a lot of cases, those immigrants didn't even vote. And so on some level, when you're thinking about policy and politics and voting, we're talking about a completely disenfranchised community that theoretically couldn't influence the decision maker, the legislator, because they couldn't vote for him or her one way or the other. And yet it was their physical presence. It was the fact that they took the time to be there that really made a difference. Whether you agree with what they were trying to do or not, the fact that they were just there made a difference to legislators. And legislators realized, wow, I mean, these people are taking the time to come here. A lot of them don't even say anything, but we know they're with this group because usually what happens is an organizer will say, can everyone who is here with, let's say, CASA of Maryland, please raise their hand? And everybody raises their hand, or stand up, and so everybody stands up. And so the immediate impact of that is just that they're standing there, they're being present. And the legislators then have to really take into account that this is not an intellectual exercise, this is not an abstract exercise. When I make a decision to be, let's say, more harsh on this population, there are real people, actually those people that I see here today, who I will be affecting. And that's a hugely important dynamic to try to bring to the process, because otherwise it is easy. And we all know this from our personal experience, right? I mean, there's far off lands and things in the world that we pretty much know nothing about. It's easier to sort of forget about that, right? But when things are in our face, when there's people that we actually know, you start thinking about things differently with respect to that. So I would dare say, even though I haven't personally experienced, that if we had more registrants in Annapolis being present, it would make a difference. It would absolutely make a difference. And much more so if the registrant is ready to go up, testify, describe their experience, describe the effects of the registry, of the policies that are affecting their lives. I dare say, I think there can be no doubt that that would make a positive difference for your community. And so I would really encourage that.
I would, and those who would like to speak, who are registrants, I encourage you to do that. What hasn't worked so well in terms of testimonies is if you go up and say, I am a registrant and I think, or that has not worked well because people turn off. It's that stereotype, you know, okay, you're a registrant because you're a sex offender, that means you're a baby raper, end of discussion. You know, they're gone. But if you're just up there and you just say, I'm a constituent and I think, that's fine. There is nothing out there that says you have to go up there and say, I'm on the registry. What I would recommend, of course, it depends on what the bill is, what you'd be arguing anyway. But what I recommend for anybody who's on the registry who would like to come and testify, plan on focusing on the Constitution, on costs, and on the effect to your family in this particular, you know, where that's relevant, rather than on anything with you. One-on-one, you know, if you wanted to go to Annapolis or make a phone call and talk to that legislator about your personal situation, you'll get a little further. But there in the testifying in that room, you're not, because the emotions are just too high. So that's been my experience. I especially encourage family members, though, to come and testify, and everybody to show up when there's a bill being heard, because as Richardo said, that's really powerful.
I think there's got to be a combination. There's the constitutional issues, there's the cost issues, there's the effect on the families. And I would be happy to work with you all. You need to sort of strategize what your communication is for any given bill, any given hearing. And this was just a really sort of basic introduction to public speaking, but we've had the fortune at the public defender, Public Justice Center was where I used to work, at the public defender, of working with a couple different communications consulting firms. And there are a number of tools you can use to really identify the issues that you need to hit. This is typical of law professors, of scientists who come down and testify. They will have like a 15-page written testimony that they will introduce to the committee, but they will not then try to actually go over the 15 pages. They'll highlight the 2 or 3 most important things in their verbal testimony, but then make a specific point of referring the committee members to the written testimony and say, and I have provided written testimony for the record that's much more detailed. Please refer to that, or please call me if you have any follow-up questions about what I'm testifying to you about today. So that would be perfect. If there's a situation you need to describe, you can say, you know, what I'm addressing here, I'm only hitting the high points. My written testimony provides the details of this that you may want to consider later. So that's great. There's a specific format. So the person who's introducing the bill, the delegate or the senator, will get up first, and usually just have a very brief introduction of the issue. And the reason why that is because it's sort of a matter of courtesy that the other committee members are not going to begin asking a lot of hard questions of the person who's introducing the bill. They'll be more or less very respectful, allow the person to say the 2 or 3 things that they want to say about their bill, why they're introducing it. And then it's usually the rest of the panels, the rest of the supporters of the bill that will go after the sponsor that get into the details of the particular proposal. So that's sort of, if you will, the first half of the hearing. And then at that point, anyone who is opposed to the particular bill or policy will have an opportunity to testify. And there's a lot of bills in Annapolis that get introduced, particularly in the name of getting tough on crime, where you just have people testifying for the bill, and frankly, OPD, we're the only ones who have signed up to testify against it. And so there's a little bit of a disbalance there. But the democratic process requires that everyone be given the right to testify. And so you indicate on a sign-up sheet whether you are for or against the bill. And then anyone who's for the bill goes first. Anyone who's against the bill goes last.
Yeah, I don't know if you touched on it or not, but should we be prepared to be answering questions from committee members after our statement? I mean, what kind of tips would you give on how to deal with, what to answer and how to answer?
I think the predominant tip is don't answer if you don't know the answer. Too many people will try to say something just because, I mean, it's human nature. You know, you're kind of put on the spot. You don't have anything immediately available to you to say, I know this or that, you know. So the first thing is to, again, you know, in line with my initial recommendations, you're the expert on your experience. You're the expert on what you know. Any questions that are trying to get you to talk about something else, you can just very easily and very respectfully say, I don't know about that, Senator, or I would need a little bit more time to think about it and get back to you. So that's my number one tip, is just catch yourself anytime you're being sort of tempted to try to address something that you may or may not know. And then they'll give you the time, actually. You will have time. Usually, voting sessions on a particular bill after it's had its hearing are more or less maybe a week to 10 days after the bill has been heard. And so you do have some time to respond to any questions that you couldn't answer via email, via phone call, or getting that information to somebody, a staffer, who will then communicate it to the committee. So don't feel pressured to answer anything immediately on the spot. But there can be any number of questions. Sometimes people are really interested in kind of the personal angle on an issue, and they'll ask people who are testifying to clarify something or talk about that. Other times, you know, the lawyers in particular will ask about legal aspects, and they'll usually know who they need to ask, you know, within a particular panel of testifiers who might be the legal expert, et cetera. But sometimes you'll get a sort of curveball that you weren't expecting, and that's the biggest piece of advice on that.
I was just going to add, as far as questions go, there are, especially on the House side, but also on the Senate side, there are a couple of senators or delegates who are going to try to ask personal questions. So, are you on the registry? And you have a right to say, I'm here to talk about the bill. You know, if you're comfortable with saying, yes, I am, that's fine. But don't let them go further, because what they will want to do, again, is discredit you. Well, you're only here for self-service, which is actually a perfectly valid reason to be there, you know. Absolutely. But in this context, again, they're going to try to, you know, they will ask you that question specifically to discredit you. I've seen that happen. So, you know, if your offense was something that when you tell somebody what it is, they go, "You're kidding, you're on the registry for that?" Feel free to go ahead and tell them. Anything else, though, I'd recommend you just deflect the question. Just plan ahead of what you're going to say if somebody says, so you're on the registry. Because then as soon as you do, they'll say, what did you do? Okay? I mean, every time. And you definitely don't want to go there, because that has nothing to do with the bill, clearly. And so have a comeback for that. So I just want to mention that. So it's good to, yeah, it's definitely good to be prepared to say, I'm sorry, I'm not comfortable answering that question, even if that's all you say.
There's something very real about someone going there and saying, I messed up, but I'm trying to make the most of my second chance. Can you give that to me? Can you be real about that? If you're not in a position to say you messed up or to say you're making the most of your second chance, then you do have to think about how you want to testify. But if this community is anything like the rest of the ex-offender community, and again, I want to be careful about making any assumptions here, that's a powerful thing. It's a powerful thing. And there's not a person on this earth who can't relate to that, because there's nobody here that's perfect. Now, there's a lot of legislators that are going to act like they're perfect, and they don't understand. They don't understand what it means to make a mistake, and they're going to be very self-righteous about it. And you do have to be prepared a little bit about that. But I do think there's something very powerful about saying, this is what it is, and I'm just trying to make the most of it. Help me make the most of it in a meaningful way. Just one other follow-up to what she said, and I feel comfortable saying this because the committee members themselves say this in public. The Judiciary Committee, so on the House side, the Judiciary Committee, which is 22 members, do refer to themselves as the pirate ship, okay? And what they mean by that is when you go in there and you testify, it can get crazy. It can get absolutely crazy, and legislators will begin to start arguing with each other. They'll start arguing with the person who's testifying. They'll get back to a point after taking a route, talking about something completely different. And in fact, this week, that happened in a hearing, and they literally all sort of laughed together when one of the legislators was like, well, we really have earned the name of the pirate ship again, haven't we? And you know, everybody just sort of knew that. Don't let that discourage you. Just know that that's a possibility. The Senate side, Judicial Proceedings Committee, is much more formal. It's smaller. All of your Senate committees are essentially 11 members, so half as big. And the chairman of that committee in particular does a fairly good job of keeping a lot of decorum and order in his hearings. So they're very different. They're very different animals. One good thing that they've done in the last couple years is they now have an electronic, almost like a little billboard out in front of the Judiciary Committee that does, once 1 o'clock actually comes, they'll post it, and then you'll see what order the bill is in. At that point, you might be able to tell that you're like bill number 6 or so. You know that you've got a little bit of time to go grab a snack, that sort of thing. But you also can't be overconfident because you just never know. Some hearings are going to be a minute long. And so you just have to, it's always, you know, you can have someone like your fearless leader, Brenda, you know, just texting you when the bill's going to start, and you can come back and get ready to testify. Again, this is at the level of rumor at this point, but I very strongly suspect that there's one senator in particular who is trying to modify some of the registry requirements this year in a way that's, I guess you could say, progressive, that's easing some of the net in terms of who's going to be caught up in having to register. I do know that there's some talk afoot about changing some of the statutory rape provisions and easing that a bit in recognition of what some legislators call sort of the Romeo and Juliet scenario, where you essentially have young people who are agreeing to have consensual sex with each other, and there's really no criminal intent or criminal behavior occurring, but because of the way our laws are applied, you know, maybe subjecting certain people to potential criminal penalties related to that.
Just to follow up, I mean, I've understood that, you know, it's good for us to each contact our own representative in our jurisdiction. Mm-hmm. But here, an example of a senator who seems to be sympathetic to our cause. Would not be beneficial for all of us to send him kudos and letters of encouragement and mm-hmm. thanking him, you know.
Absolutely.
Those things would make a big difference.
They would. You know, it definitely makes a difference if they know that you're a person who could or couldn't vote for them. and who's going to be making a decision about whether to vote for them based on, a particular area. But all legislators understand that the bills that they're passing, the policies that they're making, affect the entire state. And if they're hearing from people that are going to be affected one way or the other, they take that into account. So absolutely. How can someone presume to pass a law, hasn't really done their homework, hasn't really reached out to figure out how would this affect, and then sort of come back after the fact and be like, can you tell me what's going on out there? Sounds a little ridiculous, but that's the sad truth of part of the decision-making process. And again, from the point of view of the public defender, I think it is part of that political expedience, the political expediency of being tough on crime. So people just sort of get out ahead of that, they ride that wave, and then a year or two later they realize, wow, this didn't actually play out the way that we thought it would. So whether that's frustrating or not, the truth is it is a golden opportunity anytime you have to educate a legislator if you're engaging in that conversation. And it might feel like a little, too little too late, but take that opportunity because the truth is a lot of them will just vote for things because somebody else asked them to, or they just think generally this is the way they should go, but they haven't had a very particular sort of sit down with people or even just the facts to really analyze what they truly think if they knew sort of the details of it. There are people who will simply never do anything to ease the criminal justice status quo and who will basically every single time vote for anything that looks like it's getting tougher on crime. There's entire political campaigns that are based on nothing else. And so for those people for whom those campaigns have worked, they're like, it's not broke. Let's not fix this. I'm going to continue to be tough on crime absolutely every single time. Those particular legislators, we know that they're a no vote on almost every single case. But I have to tell you, and I want to encourage you, there are some crazy votes sometimes. There are people who will latch on to a particular case or the story of a particular person, and even though they've gone this particular way every other time, something moves them to sort of make this their exception. And that's real. That's real, and that's I think part of the personal connection often that can be very effective.
Is everybody strictly limited to 3 minutes?
Well, so here's where there's going to be a difference in your committees. So in the Judiciary Pirate Ship Committee, it ought to be 3 minutes, but it might not be. Now, this can actually work in your favor because in that case, there are times when if you're against the bill, you may be allowed to speak more than 3 minutes. I think there was a person in the back you had asked about combining oral testimony with written testimony, anticipating that you would be limited to 3 minutes. There are times when the judiciary is so sort of fast and loose that everybody gets to sort of showboat and spend as much time as they want to testify. There's a practical limitation to that, though. If your testimony is 3 minutes and it's good at 3 minutes, what are you spending minute 4 and 5 talking about? Are you repeating yourself? Are you sort of beating a dead horse? Are you starting to talk about things that you're actually not as confident or as knowledgeable about just because you want to keep talking? So you gotta decide for yourself what works and go with that. And when you're done, you're done. But that's the judiciary side of things. I would still say, assume you have 3 minutes, construct your arguments and your presentation to 3 minutes. If you happen to be given more time and you have something else that you'd like to say that you think will be effective, go for it. On the Senate judicial proceedings side, however, just about nobody gets more than 3 minutes because the chairman is very, very controlling of the proceeding that way. The governor, the lieutenant governor, they'll get more time, but pretty much beyond that, maybe a county executive, but they don't get much more than 3 minutes on the Senate side. But the judiciary is a little bit of the Wild West.